Hello and welcome to another episode of The People's Law. This is where the law meets the people. Remember, this show is meant to help you understand your rights, your responsibilities, and the legal systems that we interact with on a daily basis. On today's show, we're going to be discussing debt and debt recovery. I know it's something that most of us have grappled with or have had an experience with, and there's so much information that's there to learn from what the law says about debt. So please stay tuned and you have a lot to learn. We received an overwhelming response on our topic from last week, especially with regards to the issue of debt. To help us delve more into that topic, our topic for today is debt and debt recovery, so that we can help you understand the laws surrounding debt and what is supposed to happen if you are in debt or if somebody owes you money. And to help us delve into that topic, we have Counsel Paul Mayaka. Counsel, thank you very much for coming on the program.
Thank you for having me, Sarah.
We're so happy to learn from you and to know what actually having Congole entails.
Happy to teach, as the case may be.
Okay, so maybe just to start with, what constitutes a legal debt, or is there such a thing as a legal debt?
Well, yes, there is such a thing as a legal debt. I think a debt is simply an obligation you owe to another person. Normally, it's usually a financial obligation you owe to either a bank or a non-bank individual to offset that obligation at a later time. Usually, it's based on set conditions, which could be with interest, collateral-based, and the like. So, yes, there is an illegal debt as well. I think those are debts that are not governed by law. Strange practices that are happening out there. But yeah, there is such a thing as debt.
So if somebody is owing money to someone who does not have a legally registered lending business, would that be considered an illegal debt?
No, sadly, that's a very legal debt. Like I've stated before, a debt is basically an obligation that you have to another person, so to offset another person. So, for instance, you, Sarah, and party X could agree, look, I'm facing financial challenges. I need to pay rent. And my obligation to pay rent has fallen due and I'm not able to make it. And party X, who's not a bank, a microfinance, or who's not in the business of lending out money, can decide to give you that amount on conditions as well. And I think one of that on condition, but I mean, the law would obviously come in at some point to restrict that kind of practice. But yes, you can have a debt to someone who's not licensed, for lack of better words, who's not legally in the business of providing financial services.
So whether licensed or not, you have an obligation to pay back.
You have an obligation to pay back.
So what exactly does the law require from a lender before giving out a debt to someone? Are there any requirements according to the law?
Yes. So I think at this point, I would want to focus mainly on the legal debt. I think a split that has just been created here. So here I'm speaking from a position, I think from a position of a microfinance,
or
a bank, a financial institution, or a money lender, or someone that is compliant with the Money Lenders Act. So there are a number of obligations that exist, and I think some of them are statute imposed. Like, for instance, there has to be an agreement between Sarah and party X, and that agreement needs to be reduced in writing. And I think that's something that's very, very important, especially for a legal debt. It needs to be reduced in writing. And then what should be contained in that document should be the specific terms of that particular obligation or that debt. So Sarah is meant to pay back that debt in December on such and such conditions. And then that document could also have other things. For instance, if I think the microfin requires security, I mean, they could ask you to pledge some security. So that document should be able to state all those things. So that document must also state the rate, that is the interest rate. If I'm speaking from a money lender's position, that interest rate is actually fixed by law. So to say, I mean, I think the law caps how much interest the money lender can charge. So you are obliged as a money lender to tell the person that's borrowing what the terms and conditions are for that particular facility. It could be general, it could be specific to that customer, but that's one of the obligations that's there. And then the other obligation I think that many people tend to forget is, I think, the data protection aspect. So obviously, when you're getting a facility from a bank, you give them your personal data, your biometrics, or know your customer, KYC data. That is your name, your age, your gender, your address, and the like. So I think they're obliged to keep that data in a particular way, not to disclose it in an unlawful manner, and the like. But yes, basically that should respond to that question.
Okay, so is there a limit on how much interest can be charged on a loan? And should this be predetermined?
So yes, there is a limit. Yes and no. Perhaps I think you notice most of the lawyers that you bring here will probably have this yes and no answer kind of situation. I think that's what we're taught. But yes and no. So I'll give you an example. It depends. So firstly, if the lender is someone that is compliant with the Money Lenders Act, that is actually the most common, and I think most of the viewers out there would agree that most of these people that actually give out money readily nowadays, quite easily and perhaps even quickly, are money lenders. These are people that apply somewhere to have a license to give out loans. The law has been specific on what amounts to good interest rates. In fact, I think it defines certain interest rates as harsh, excessive, and courts have actually come in to agree with what the law states. For instance, the Money Lenders Act does not allow interest rates to exceed, I think, 48% per annum, give or take. I could be wrong, and it could be amended as we're speaking, but yes, 48% per annum should not exceed that. Anything that exceeds that is excessive. In terms of banks and microfinance institutions, or those institutions that are compliant with the Banking and Financial Services Act, those are very regulated, actually. I think Bank of Zambia monitors the interest rates there. However, I think basically that's it. The law is quite restrictive in terms of what interest rates are. They tend to protect the market. They don't. I think the law does not like abuse, so it's quite restrictive there.
So maybe not to term it as legal or illegal debt, but rather regulatory or formal and informal debt. So for the formal debts, for the ones that are given by the banks and the microfins, those that are registered and regulated, what are the legal requirements that they should perhaps request from people before giving out loans? Okay. Or is it at their discretion?
It's actually not at their discretion. I think the law has guided in terms of what is required. So firstly, obviously, the law requires someone who's borrowing money to give out certain information. So for instance, you need to give your KYC data. Some banks would even require you to give proof of residence. So they would ask you for your water bill, your electricity bill. I wonder if those are still given nowadays, but yeah. A water bill, your electricity bill, or some individual somewhere, perhaps a pastor or your advocate to vouch for your residence. There are a number of requirements that are prescribed by law. Some of them are actually prescribed by practice, for instance, such information. Also, for instance, if your loan, you intend to take out a secured debt, you're required to disclose that security. Perhaps even allow the money lender or the institution in this case to vet that security. So if you're going to deposit your title, they'll probably have to run checks at the Ministry of Lands. I think they also have a registry, PACRA, but there are a number of items that are required before you obtain a debt. And most banks, in fact, I think I can safely say all banks, are really compliant in terms of this requirement because of the industry they.
Okay, so when a borrower fails to repay a debt, what are the legal steps that a lender should take to recover that debt?
No, that's a very good question, and I think that's an important question. So the law has also created a process by which a lender can recover a bad debt or a non-performing loan out there. I'll start with the non-legal aspect anyways. Primarily, they tend to start with negotiations. Most lenders start with negotiation. It's usually the primary mode of debt collection. And in fact, from my experience, most of them would try and negotiate with you. Look, I mean, you're falling behind on your payments. Do you need to perhaps refinance this loan elsewhere? Do you need to extend this facility? So they'll start with negotiations. They'll reach out to you. What needs to be done? What can be done? What's the challenge? And in extreme circumstances, which are quite many, sadly, the court would have to litigate. So there are processes depending on the type of debt. So if it's a secured debt, for instance, let me give an example of a mortgage. It has to start from scratch. You have to issue out a demand. You have to go to court. You take out an action. You go to court. During that time, even I think it's important to mention that you, as a person that took out the loan, still have an obligation to redeem that particular parcel of land. It goes all the way until foreclosure, and once foreclosure is done, there's also still some room for you to redeem that particular parcel. That is an equitable right of redemption. And until the final end, when that property is actually disposed of and the residue given back to you, or in whatever, depending on the circumstances that are happening. But it's an entirely legal process, and many financial institutions tend to follow this process quite well.
So is public shaming, threats, and repossession of collateral without a court order, is that legal?
Sadly, it's not. There's this increasing trend by lenders to just do strange things. I'll give you an example. Some gentleman took out a loan with some financial institution, and that financial institution just woke up one morning and went to Ministry of Lands to change title of that property. In fact, the gentleman was even paying. I mean, he had paid quite a substantial amount, only to find that his land has changed ownership. Sadly, it's not. It's actually quite illegal, and and the courts tend to frown upon such behavior. You've talked about threats. The law tends to frown upon that. In fact, I think there's sufficient legislation that tends to protect people from threats, whether threats to life, threats to property, threats to family. I think the penal code is quite instructive, and now with the new Cyber Crimes and Cyber Securities Act, threats are really frowned upon by the law, and they're really dangerous, and they're not a proper way of debt collections.
Mm-hmm. So we're still talking about debt and debt recovery, and you are still watching The People's Law. We're going to go on a brief break, and we'll be back shortly. Welcome back, and you are still watching The People's Law, and our guest for today is Counsel Paul Mayaka, who's helping us understand what the law says about debt and recovering debt. Counsel Paul, so speaking about loan sharks and savings group, does the law recognize these two facets of lenders?
That's a very good question, and I think that's what is happening in society today. So loan sharks, my definition of loan sharks, and I think common definition of loan sharks, is an individual that just starts giving out loans. Not licensed, not regulated, just some individual that wakes up to say, look, I've got excess funds.
And they decide their own interest rate.
They decide their own interest rates. They decide how to collect. And most of the time that collection could even be at gunpoint or at knife point. And threats, as what mentioned. So loan sharks are really not operating within the confines of the law, so to speak, unless perhaps, obviously I have defined them there. So their practices are actually also quite frowned upon, like we've talked about. These are individuals that will just wake up at 02, come to your house, knock on your door roughly, drag you off your TV or your bed and get your TV, and perhaps even start threatening your neighbors. Perhaps some would even come with a gun. I've noticed my colleagues from a certain community in Zambia, that actually move with guns. They loan within that community and move with guns to collect. Such practices are actually thuggery, and the law tends to frown upon it. There's a lot of legislation that tends to protect people against such people. However, most of them go unnoticed because, I mean, if Sarah is threatened and she pays, it goes unrecorded. Perhaps even the authorities don't even notice. It does happen. It's very bad. And I think the law tends to protect people, especially when they do come out and when it's noticed. In terms of savings group, I think there's a policy by government to have financial institutions share money, for lack of better words. Some of them have proceeded to register under the Cooperative Societies Act and various pieces of legislation. And we've actually also noticed a whole promotion. Some banks would even have packages for savings groups and the like. These are actually okay. They allow the unbanked to have access to access to funds quite quickly. They allow people to access financial support as and when they need it within themselves. So perhaps a family savings group, Sarah and family savings group, get to save up a few kwachas there, and when Sarah needs to start up a small venture, she picks from that pool and she pays out. So those are actually quite okay, and it depends on their constitution, as in how they're formed, but the law tends to allow this, and it appears society tends to gravitate towards them because they provide this facility, this service to people that normally wouldn't be given a financial facility when they were there to go to a bank. So yeah.
Well, also considering the savings group as well as the loan sharks, despite the fact that they may have the resources available to lend to the public, what are some of the legal risks would you say are involved in people borrowing from savings groups and informal money lenders as opposed to going the formal way?
I'm not very sure about the risks as regards to savings groups, and perhaps I wouldn't even delve into them that much. I would want to focus mainly on the risks that Sarah faces when she borrows from Loan Shark X. Loan Shark X is not regulated, so they get to come up with strange interest rates, sometimes triple, if not more, than the principal. And sometimes they tend to come up with strange payment periods. You ask for a facility of 10 kwacha today, and suddenly they tell you, no, you need to pay me back 500,000 kwacha by 12 hours tomorrow. I need the 10 kwacha today. Where am I going to get 500,000 kwacha tomorrow? And when you don't, they tend to grab assets, and sometimes it tends to be violent. So the risk of you losing property is quite high. You losing a peace of mind, and in the age of mental health, your mental peace is quite high. Normally people are encouraged or are discouraged in this case from obtaining facilities from our colleagues that we're terming as loan sharks in this case.
So speaking about the savings groups, which I think is one of the most common, a lot of people are in different savings groups, a lot of people are in different Chilimba groups. Are the Chilimba groups acting within the law when they decide to repossess the property of their members if the member has not paid back a loan that they got from the group?
So no, not at all actually. Any activity that goes outside the law is very, very bad and very, very illegal, as you've put it. There's an entire process that has been created that allows people that are aggrieved to seek redress. So, for instance, if Sarah and Sarah loans me money, she extends a facility of 10 kwacha to me. That is governed by the law of contract. And where I default, Sarah has got she's got the right at this point. She's got the locus to, approach a court and say, look, there's this issue. Can you adjudicate? What are my rights? And the courts tend to be very fair in such situations. So any activity that goes beyond the scope of the law is actually not okay. Where there's such a situation, if that Chilimba group, as you've put it, and also obviously having in mind how it was constituted, decides to collect, it must do so within the confines of the law. Please.
What role do the courts play in the process of recovering debt?
Mm. The courts play a very, very vital role in many of the things in society today. I'm an officer of the court, so I'm obliged to say that, but in reality, they do play a very, very important role. They keep the peace. The acrimony that is created, I think there is a saying in society that if you want to lose a friend, just go and borrow money. It's unlikely that I'll ever talk to you if you get my money and don't give me back. I'm joking. But yes, the courts tend to keep the peace. They ensure that rights created and responsibilities and obligations created by the parties to any transactions are respected and are honored. So where I give you, we contract and I default, the court will apportion to say, look, no, Mr. Paul, that's not the way to go. This is the right way to go. So they keep the peace. They keep finance. They keep finance safe, and they keep our money safe as well. So it's really important that it's really important to mention that the role that the adjudicators play is really, really vital in society.
So would it be right to say, in an event that there is conflict between the lender and the borrower, that matter can only be resolved in court? If they are not able to come to an agreement, whether it's because the lender is being difficult or coming up with ridiculous interest rates or threatening, or if the borrower has just refused to pay back, do such matters always have to end up in court for resolution?
I'm going to give you the textbook answer, the yes and no textbook answer. Yes, it's the court's role to ensure that adjudication is done in terms of rights and responsibilities in such a situation. Normally, and I want to say normally, most of these things end with negotiation. They do not get to go to litigation. And I think business is normally done out of court. So, I mean, if I'm in the business of offering finances, I spend so much time in court. I'm spending money and spending time. People tend to negotiate and sort issues outside court. But the court is really, really important, where there's a deadlock, as you've put it. I mean, there's no other way. It's the last resort. Always go to court. That's the safest way. Your rights will be protected, and be quick about it, because I think there's a statute of limitations in terms of certain things. I think after 6 years, and perhaps even in the Money Lenders Act, I think that's after 12 months. It's time to be corrected, 12 months there and about. But yeah, it is important that you go to court where you feel your rights are being abrogated, you're being abused, or for instance, in this person is just defaulting and he has the capacity to pay. Even if he doesn't have the capacity to pay, the courts have an important role to play.
Okay. Well, you're still watching The People's Law, and today we are still discussing debt and debt recovery with our guest, Counsel Paul. We're going to go for a short break. We'll be back shortly. Stay tuned. Welcome back, and you are still watching The People's Law with me, Sarah Mupeseni, and today we are still discussing the topic of debt and debt recovery, Nkongole. And our guest is still here, Counsel Paul Mayaka, and he's helping us understand the laws around debt, what is supposed to happen when someone owes you money or when you are being owed money. Now, Counsel, is there any circumstances in the law where a debt can be cancelled? Somebody has borrowed money, and then you go to court, and then the courts decide that they will not pay back. Is there any circumstances that can lead to that kind of a decision?
Yes, and no. It's a textbook answer. I think it should be an exam question. You should be able to answer yes or no. If you don't, you fail. But yeah, yes and no. So there are a number of situations that allow there are a number of circumstances that can exist that can render a debt unenforceable. So, for instance, if you're meant to be compliant with the Banking and Financial Services Act and you're not compliant, it might be difficult for you to recover. There are circumstances where it might be very, very difficult for you to recover. You're meant to be compliant with the Money Lenders Act, and you're not compliant, for instance, in terms of the interest rate, or you have bad loan practices or predatory loan practices. The court tends to take decisions that, in some circumstances, a facility tends, a debt tends to, the court says, no, actually, this person doesn't owe you anymore because of what you did. So there are a number of situations that happen. So even when you perhaps there's an illegality happening. So the court tends to balance on the rights of the parties involved, the obligations of the parties involved, and the interest of the parties involved.
So what are some of the rights of the borrower that you can highlight in an event that they got money, whether it is from a loan shark or from village banking, Chilimba, from a bank, in an event that they're not able to meet the obligations of that loan, and then they're being pursued? What are the rights that they have? What can they consider illegal and illegal pursuit?
Okay, so I think just off the top of my head, there are a number of practices that are actually quite illegal. So, for instance, issuing out threats. I think we've mentioned this. Where I come to you with a knife, and just threat, issuing out threats, issuing out insults. That is bad debt collections practices, frowned upon by the law and even by society. So, obviously, if someone owes you money, just don't threaten them. The law tends to protect people against that. In fact, there's a lot of legislation now that tends to protect people from threats. There are also a number of things. For instance, you don't just wake up at 02:45 and then because Sarah deposited her title with you, you say, no, I'm just going to walk to Ministry of Lands, and then I'm going to I'm going to even give them a document to say this person has sold me this land at this amount. You don't do that. I think the law tends to protect people against that. There are a number of things. For instance, we've seen situations where Sarah walks into microfin X, maybe they even put it moneylender X, with the purpose of obtaining a loan facility to start her gardening or whatever it is that Sarah likes to do. And then instead of being given a loan contract, the loan individual gives you a letter of sale for your house. And Sarah, because she wants the money very much, and she's told, no, these are the things that you do. When you default, that's when we enforce this. I mean, no, don't do that. The law tends to respond aggressively against people that do that. I've also noticed situations, situations where, and this is very important for me to mention, and I need to be very careful with the statement. I've noticed situations where Sarah is owed money by Paul, and Sarah has failed to collect money. She walks to a police station and she converts our very good and able men and women in uniform into debt collectors. Police officer X calls, Paul, you should give this person money by 10 hours or I'm coming to arrest you. No, that's a civil matter. I think the police should concentrate on what the act says they should do and not engage in civil matters. We've also seen situations where, that's just off the top of my head and from experience, and this is very close to my heart. It's something that is happening now. Sarah walks to police station X and finds someone who's not even a police officer, a police reserve, for instance, or an individual that walks past the police office or the police station so often and they feel like they're a police officer. That guy picks up the phone and calls Paul, I'm going to arrest you. I'm going to come and shoot you. I'm going to do this. I'll take you. It's a crime to borrow money and whatnot. That's also a very bad debt collection practice. It's a very bad practice in the market, and that's something that perhaps authorities tend to, and the courts tend to frown upon. There are a number of items, and I think too numerous, and we might need more time to delve into each and every one of them.
I think I like the fact that you have mentioned the aspect of a police. We have heard in a lot of instances where people have borrowed money from a Chilimba, they've borrowed from their savings group or from a loan shark, and they end up in police custody. And the charge that has become very famous with relating to debt is obtaining money by false pretense. So maybe you could just help us understand, what does the law mean when it states what is obtaining money by false pretense?
Okay. So the Act is very specific in its definition of obtaining money by false pretenses. And in its definition, it creates characteristics. So I think in a simpler way, I think it creates small ticks that you need to, small boxes that you need to tick against in order for an activity to be called obtaining money by false pretenses. So obviously one of them, I think, is just in the name. Obviously, I obtained money from Sarah pretending that I have a vehicle somewhere there that I'm selling. I don't have a vehicle. That vehicle doesn't exist, and I'm not selling a vehicle. So I obtain money with no intention of giving you back that money. There are a number of circumstances that would define obtaining money by false pretenses. But basically, I think the penal code is quite specific on what amounts to obtaining money by false pretenses. And many of the men and women in uniform are well trained. They tend to know exactly what they mean when they say this is obtaining money by false pretenses. And when they call you for something that they know very well is not obtaining money by false pretenses, they tend to know exactly what they're doing. So the law is very clear in terms of what is civil and what is criminal. The line is quite straightforward, really. It's very difficult to blur. But this is what happens in society. And I do know for a fact, I think you could speak to Mr. Chilabi that was here. He will tell you to say that the police high command actually responds quite aggressively to police officers that tend to abuse their authority. And the law itself is actually quite aggressive against police officers that tend to abuse their authority. They're meant to protect you. And so going beyond the confines of what they're meant to do is really unfortunate. But that's what happens in society today. And that's something that we need to address as a country.
Okay. So we're going to go on a short break, and as usual, we're going to hear from the public on their opinions and their interactions with debt and debt recovery, and we'll be back shortly. Tifuna kushitako find out vemuziwa pali malamulo ya mu Zambia muntu ngati aina nkongoleyano mufuniko kuchita bwanji process ya mufuniko konka according to law ni process bwanji kutenga ndalama zanu
apo ngati twavutana na wewe risiketa chabina enda kuleba oro ku illegal resource so that vanitandizira kuti ndrama zijazatenga bwanji.
Is it? Do you think it's legal for someone to take someone who owes the money to the police?
I'd assume so, because generally when someone has committed an offense against you, you'd want to report them to the police. But I think, from what I know, the right route would be going to a debt collection agency.
If someone owes you money or if you owe someone money, what is the legal procedure and steps you take to recover that money?
I think for me, what I understand is that if somebody owes you money, I think the legal way that you should take is either, according to my personal knowledge, like from where we live, first you have to acquire the police and you lodge in your reports and all that. Maybe they will guide you to either acquire for a legal practitioner or either find someone that can help you to you return or to get your money.
Okay, wa Francis, kamuzi wako chani pali malamulo ya Zambia muntu ngati aina nkongoleyano then avuta kukubweza nani ndrama mungachite chani kulingana na malamulo ya Zambia.
Unakuwa kuliba obvious ileta ini.
Welcome back. Those were some very interesting views from you, our viewers, and the general public on their understanding of the laws around debt and debt recovery and their experience with it. Now, as we conclude the show, Counsel Paul, I would just like you to advise that person who has lent out money to someone, but they have struggled to recover it, or they feel helpless. They've tried everything in their power, but they're not getting that money back. What legal steps can they take to recover their money?
Okay, so primarily when you're in this business, ensure that you have your lawyer on speed dial. Always ensure you reach out to your advocate. They tend to guide you faster and they tend to give you results quicker. The Law Association of Zambia has also created a number of bodies that tend to help those individuals that perhaps have entered into a contract with another person and are unable perhaps to pay for counsel. So I think there is the Legal Aid Board. I think there should be also the Legal Aid Clinic for Women and a number of other bodies, other institutions that are available out there to help people. So always reach out to your counsel for advice. The courts are actually also quite open. So I think there should be the small claims court that tends to address, such kind of debts, especially on the smaller end in terms of the spectrum. There's a cap as well as to what kind of matters go there. There should be the subordinate court as well. And nowadays, I think it has been increased. Their threshold is quite high now, so they can adjudicate up to matters as high as to 1 million kwacha there and about. The superior courts there. So I think always walk to the courts. Do not resort to threats. Do not resort to illegal or unfair or unnatural debt collection practices such as threats. I think I tend to mention that a lot because we see that happening a lot in society. So there are a number of mechanisms that tend to protect the lenders out there, protect their facilities out there. And I think even the contract itself. So some of them could be secured and unsecured. So there are a number of mechanisms that exist wherein a lender can recover what is due to them.
Mm-hmm. And then now on the other side is the person that has borrowed money and they just genuinely do not have the means to pay it back, whether it was because due to unforeseen circumstances, but they're being pursued by the person that they borrowed money from. What would you advise this individual to do?
Yeah, firstly pay. But yeah, I understand the question. You're just not able to pay.
Yeah.
Things are difficult for you. It's a bad month. It's a bad year. There are a number of things that you need to do, and I think primarily is always engage the lender. And most of these lenders are reasonable, and I think I've chosen my words correct. Specifically, I think I said most. We have some unreasonable people. Most of them are unreasonable. They could extend that facility. You could go to another person that could give you that could refinance that facility. There are a number of things that exist out there. However, where threats are coming in, or unnatural, illegal, or strange debt collection practices are coming in, the law protects such people. So, for instance, if it's threats to life, you're encouraged to speak out quickly. I think the police is quite responsive these days. A call would ensure that you're protected. Please speak out. And do not keep it to yourselves. Please speak out. In the era of mental health, speak out. Call for help. And visit a court where absolutely necessary. Visit a court, and some mechanisms would exist. Visit the Law Association of Zambia. Some mechanisms will be there to protect you.
Okay. Now, thank you very much for joining us on this episode. We've been discussing debt and debt recovery. Don't forget to interact with us on our social media platforms. You can ask your questions there. You can give us your contributions and your feedback there. And also let us know where you need more clarity, what are the topics you'd like us to cover. We're more than happy to indulge you, because this show is for you, for all of us to learn what our laws actually say about the different situations in our lives. We're looking forward to seeing you again next week. Take care.